Hi, welcome to today's presentation. I know the answer, but I don't know why. Practicing law in the age of machine intelligence. My name is Ben Snipes, speaking for Wolters Kluwer, Legal and Regulatory, US. Have any of you played the game Marco Polo as kids? That's where someone closes their eyes and says Marco, and everybody around them says Polo. The person with their eyes closed has to guess where the people saying Polo are. By saying Marco and Polo back and forth, the person with their eyes closed guesses more and more accurately where the people saying Polo are. This is actually a type of machine intelligence, this back and forth guessing to get to the correct answer. When you think of it, Google actually works much the same way. When you see the Google prompt, that's sort of like someone saying Marco. And someone putting in a query into the prompt is like saying Polo. What Google does in return is then guesses more and more accurately what the correct answer is. It does this not only through its own machine intelligence, but also uses human intelligence by looking at what people link to other sites and what they click on. This prompt, question, answer is just Marco Polo played over and over again. Both Marco Polo and Google use something called Bayesian statistics. This is an old but a very particular type of statistics that's used by machines to get more and more accurate guesses as to the correct answers. And you'll see this used by machine intelligence throughout the law. But what is machine intelligence? Well, it's the same thing as artificial intelligence. It's just there's nothing artificial about it. It's machines using math to get to correct answers. But there's a bunch of technologies that are used in machine intelligence. The three primary technologies used for legal purposes are machine learning, natural language parsing, natural language understanding. Machine learning uses the feedback mechanisms and statistics like Marco Polo and Google in order to improve what they call recall and precision in response to questions. Natural language parsing allows machines to interpret human grammar, so subject, verb, object, understanding what each part of a sentence does. And lastly, natural language understanding allows machines to use both machine learning and natural language parsing to get to semantics, or the meaning and interpretation of language in the context of other language. All three of these technologies are used in machine intelligence when applied to the law. But how can machine intelligence be used in the law to improve its accuracy and efficiency of lawyers? Well, in a legal context, machine intelligence uses various computing techniques to do really three primary things. The first is to suggest a likely further explanation or question for the question being asked. So when someone asks a question, a machine can help with the explanation, or it can also provide another question. So if a lawyer was asking something, the machine can say, well, you probably meant to ask this, which is a better question. When people use Google, they're often doing that very often. The second is to provide information likely to help a lawyer, librarian, or paralegal make a decision. So for example, if a lawyer is trying to decide what jurisdiction to file, or what type of clause to use in a contract, machine intelligence can be used to help that lawyer or legal professional make a decision as to where to file or what clause to use. Lastly, machine intelligence can be used to provide the most likely answer. And this is the most extreme use of machine intelligence. Notice that in all three of these uses for machine intelligence, the word likely is used. That's because each one is a bit statistical. It's probable. And that's different than how machines have been used in the past, with direct input and output. You do something to a computer, you expect a specific output. Machine intelligence is another layer of computing which gets to probable explanations, information for decision making, or answers. But there's a problem. There's two key limits to the use of machine intelligence for law. First, lawyers must be able to understand and explain answers in order to support legal opinions. In fact, it's imperative upon lawyers to be able to understand and say exactly how they reached a legal conclusion. It's their duty. The second is really the extent and logic and empathy of legal answers can be made quantifiable through machine learning and other algorithms. When people go to court, either for a civil claim or a criminal case, and they look to the jury or the judge, they expect something more than just plain logic. They expect a certain level of human empathy into the circumstances of the case and what creates justice. And there's a question to the extent we can use machine intelligence to actually reach similar decisions. For the legal profession, the model rules of professional conduct actually has something to say here. If you look at the model rule of professional conduct rule 1.1, it actually has a duty of competence, and that duty of competence requires a factual and legal elements of the problem to be understood. It requires attorneys to understand the use of methods and procedures to meet these standards of competence. It's actually a circular definition because it doesn't define a standard of competence, but it requires attorneys to use the methods and procedures to meet them. It also requires attorneys to keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. So not only do attorneys have a duty to understand the factual and legal elements of the problem, but they also must understand the application of technology to it. So anytime that machine intelligence is used in the law, attorneys must keep both of these things in mind. Here's an example of a machine intelligence algorithm. If you look at what is highlighted as a red box, you notice it says Boolean function of states. Actually, Boolean terminology, the ands, ors, within a certain number of words, within a paragraph, are all Boolean functions that attorneys use in today's legal research services. However, if you look at this algorithm, you'll notice it's far more complex. In fact, far more complex than any attorney, well, most attorneys, would understand. It requires an entirely different line of education. And so if attorneys can't actually understand how this algorithm provides an answer, how are they supposed to use that answer in the practice of law? Before and today, often attorneys go through casebooks, footnotes, and they can easily track back to how they arrived at a legal conclusion. In fact, it's expected that they do so and be able to stand up in front of a court and explain their answer and analysis. However, with machine intelligence, it's actually very difficult for them to track back to how they arrived at the answer unless they go through and do their own independent analysis. If they do that, what good is machine intelligence in the first place? Interestingly, if you look at the use of machine intelligence today, such as in autonomous vehicles, when those vehicles get into an accident, if you read those reports, you'll notice that it's actually very difficult for those engineers to understand what was the bug that caused the crash. There's so many parameters and variables involved in machine intelligence that's difficult for the engineers of the machine intelligence to understand what caused an accident. This has profound implications for concepts of negligence under the Paul's graph standard that every attorneys understand. It also has profound implications for the use of machine intelligence in the practice of law. Let's now look at an example of where statistics are used in law today. And actually, they're only used to a very limited extent. Going back to the early 2000s, there was a series of seminal cases called Zublocki. If you look at Zublocki 5, it's an instance where statistics was used to allow a plaintiff to sample certain e-discovery evidence. Since that case, there's been a number of other cases that continue to somewhat expand upon this concept and allow plaintiffs to statistically sample evidence to determine whether that sample represents the entirety of the evidence to draw a legal conclusion. But even where there's statistical sampling of evidence to draw legal conclusions to submit as evidence, humans often still must interpret those results. So there's a layer of human intelligence that's applied before you even get to legal conclusions still. Statistics are not used to draw the final decision that a case turns on. So here are some of the key questions. Will the conclusion of a machine as to whether a given set of documents are legally relevant ever be accepted? Will we just rely upon the statistics? or even any sort of machine learning algorithm. How far down this path will we go where we trust the algorithms to reach legal conclusions? And how will this precedent apply to all other areas of law, especially as they extend the use of machine intelligence further and further into it, either in litigation, contract review? So let me conclude. Law firms and legal departments will be pressured to use machine learning technologies to drive insight and efficiency. As one law firm gets an advantage in this respect, all other law firms will be pressured to use these same tools to attract clients and win cases. However, we must ask ourselves to what extent lawyers will be able to use these technologies. This will depend on whether using these technologies will be an acceptable standard of practice. Will it be deemed competent by an attorney to rely upon the information provided by machine intelligence? Or will attorneys always be expected to backtrack through the logic used to get to an answer in order to support it in court? I actually think the Zablocki cases and other cases since then provide a strong precedent for understanding how courts will interpret these issues. So in the meantime, vendors of these technologies, so companies leveraging these technologies in the use of the practice of law, must deploy them in a way that lawyers can understand and audit the results, or else these tools will simply be relegated to finding aids. You must understand the lawyer's duty to practice and how these tools are used and interact with that duty to practice in order for them to be used effectively. Thank you very much for listening to this today. My name is Benjamin Snipes for Wolters Kluwer.